It was a little more than 8 months back that the schools and colleges in Karnataka made the national and international headlines, the reason being trying to enforce a ban on hijab. Now, after polarizing debates, fierce politicking and several hours of judiciary's time, we are no closer to an answer. Let's in fact trace the movements of this debate. On February 5th, the Karnataka government passed an order to ensure a more homogeneous environment. The order barred all clothing articles that disturb equality, integrity and public order. The language may have been innocent, but the intent was clearly to take aim at the hijab. Now, the government order sparked protests both for and against the ban. The issue was then taken up before the Karnataka High Court. The High Court affirmed the government ban on hijab and held that this is not an essential practice in Islam and need not be given any special consideration. Now, the issue then travelled to the Supreme Court. Muslim girls claimed before the top court of the country that their right to education and their right to freely practice their religion was being affected. The Supreme Court heard the case, marathon hearings across 10 days, and reserved its judgment on September 22nd. It was this judgment that was pronounced earlier today. Now here, important to bear in mind that the judgment was to be pronounced by a bench of two judges. That's Justice Hemant Gupta as well as Justice Sudhanshu Dhulia. Now, keeping this in mind, the Supreme Court has now given a split verdict. Both the judges have given a different view on the status of the hijab ban. While Justice Gupta has upheld the ban, Justice Dhulia has quashed the Karnataka government order. Now, Justice Hemant Gupta held in his judgment that in his view, the plea by Muslim students deserves to be dismissed. He clarified in the judgment that the petitioners had failed to demonstrate how wearing a hijab was an essential practice in Islam. Moreover, he held that there was no violation of any fundamental rights. However, in stark opposition, Justice Dhulia held that the Karnataka government order as well as the Karnataka High Court order upholding the hijab ban both deserve to be quashed. He held that wearing hijab need not be an essential practice, but that it was supported by the right to life under Article 19 and the right to practice religion under Article 25. He cautioned that this was an issue of students' consent and that this was the foremost thing and the foremost concern on the court's mind was education of students. In fact, he also noted that many students, especially in rural areas, have to attend to chores at home and travel long distances to schools, and that the effort of the court should be to make this process easier. So what happens now? Well, due to the split verdict, the issue has now been put before the Chief Justice of India, who's likely to assign the case to a larger bench, likely to have at least 3 judges to avoid this tie. As for the interim, lawyers that we spoke to tell us that until a clear order is passed staying the High Court order, the ban on wearing hijab will continue to be in effect. Meanwhile, given the stakes involved, that's an entire academic year for students, the petitioners are likely to move the CJI to constitute a new bench at the earliest.